Hi, good evening, everyone. We're just putting up our presentation. Um, Hi, and good evening, everybody. It's great to see such a great turnout. Um, it's wonderful to see the interest that the health space has been garnering in the last few years, and that's further evidenced by the turnout that we have today. Um, Before we get started on the core of our presentation, um, we thought we'd just start with a bit of an introduction to the industry and what the driving forces are, because as I'm sure all of you are aware, there's been a growth spurt in investment and in entrepreneurship in the health space. While we're all bored of hearing of COVID undoubtedly played a huge role in the healthcare startups skyrocketing. When the pandemic hit, we could no longer access healthcare in the usual ways. So there was a huge spurt in entrepreneurs chiming in to bridge the gap. So we saw huge the likes of telemedicine platforms and remote monitoring, e-pharmacies, um, and other modes of accessing healthcare and drugs, devices, and the likes while not having to step out of the house. Um, like with every other sector, the increased penetration of smartphones and the internet has played a huge role. All of us have gotten quite accustomed to purchasing everything over the internet, and that now extends to healthcare as well. Um, Access, affordability, and quality are the key pillars of healthcare. And while that's always been a bit of a challenge, we now see significant leaps in improving access, affordability, and quality through digital mediums. And a lot of our startups are significantly contributing to that. The government is also actively pushing for entrepreneurship within the country. So we've got several initiatives, including the Ayushman Bharat Digital Health Mission, by which the government is promoting the digitization of our entire healthcare system. And there are also incentives being linked to local manufacturing of pharmaceuticals and medical devices and the likes. And as a result of all of these factors, there's been a market growth in the interest that investors have been showing in the healthcare sector. Of course, it's always been a sector that has attracted the investors' fancy, but since the pandemic and since digitization of healthcare has come to the forefront, there's been a lot more interest. A recent report from Boston Consulting Group estimated that the digital health market, is going to grow very significantly in the next 7 years. And investors, of course, are going to play a huge role in that. So, like I mentioned, there are certain areas which are garnering a higher level of interest, both from the startups and investors. So teleconsultations, of course, have grown leaps and bounds in the last 3 years. And in addition to just your run-of-the-mill consultations for the likes of fever and cough, you also have a lot of specialty-based solutions that are emerging. So now you have platforms that specialize in a condition like diabetes or fertility, mental health, and basically supports your wellness journey. Fitness and wellness have also come to a forefront. We've all realized the importance of maintaining good health and preventing illness. So there's been a market rise in wearables, by which you can monitor your fitness levels and your vitals and make sure everything is in check. Both the government and industry are moving towards digitization of health records, which also makes healthcare more accessible and interoperable for patients. So it's something that benefits the entire ecosystem. We're also seeing increasing applications of artificial intelligence in healthcare, which is leading to very innovative startups. Gamification is also something that we've been seeing a lot of. It sort of ties into fitness and wellness because it's largely being used to increase adherence to treatment plans. And while you would think surgery is something that would not be affected by digitization, we are also seeing a lot of very innovative startups on that front.
So, investment in healthcare startup. Am I audible?
Yeah, you're
Yes.
Perfect. Thank you. So, when we look at this slide, I'm sure most of the investors understand what I mean by risk and reward. Because when you look at investments, there is a certain category or like a percentage of risk that does lead up to a reward in most instances. But there is always a game of play here. You do look at high risk, high reward instances in healthcare startups, or in fact, in any startups for that matter. There might be 10,000 good innovative ideas, but not every idea converts to something that can be tangible or something that gives you a high reward. But in those instances, this is exactly why we look at certain diligence requirements, where we look at, okay, there are certain criteria that we look at in a startup so that we know that the startup can be viable. You look at their, capacity, their technology, or in terms of their idea, their competition in market. So in these terms, you look at it from a risk and reward perspective. If there is high risk, there are obviously chances of a high reward, and those are most of the instances why investors even look at investing in startups. So moving on to some of the advantages, most of us might know, given that we come from a angel investment background or from a startup background, about why the whole concept of startup is so important to every industry, and why early investing by investors, given diligence check that they do perform on every startup, can give them a certain level of control on the decision making that might happen in these startups right from the seed base level, where they're just developing the idea, bringing in assets, developing their tech or their platform. And that's when early investments play a role. Second, it does give ample investment opportunities for portfolio growth, helps you to divest your investment in terms of new ideas, new investments that might come up with better return opportunities for that matter. And specifically investing in startups in the healthcare space, we do see that, as Ashika pointed out in the beginning, that there is a huge digital transformation that happened in India, in fact, after the pandemic, which gave rise to a lot of focus on digitization of healthcare, and a lot of startups coming up in that space, because you're looking at patient-centric, patient-focused software or digital infrastructure that's being built. And this also gives opportunities to investors, foreign investors, to bring in investments and collaboration with startups in India. So these would be some of the advantages that you do look at when you're in planning on investing in startups. But obviously, it's not limited. There may be lots to talk here. So when we do go through our presentation here, when we talk about considerations, we look at it from three perspectives. One, from an entity perspective, that would be the startup entity. Second, from the business perspective, that is the business that the startup wishes to run or plans to run. And third, from a people-centric perspective. And Harshita will take you through these considerations specifically when we talk about startups in India.
Sure. Thank you, Tanya and Ishika. Moving on to the entity specific considerations that we face, that we've usually seen in our experience, which are very relevant and important, both from a founder and more so from an investor perspective. To be mindful of when you're looking to invest in a medtech startup. And while we will go through some industry specific and medtech specific considerations later, these are more general and apply to all sectors irrespective. Running you through this list. which is on the screen right now, the structure of the legal entity. Now, very important to understand and analyze for yourself as an investor the structure in which you are investing. So many a times it could be an LLP or it could be a company. That is straightforward. What we want you to see and analyze is, let's say you're investing in a holdco which has a subsidiary in India or outside India. You may need to consider your your remittances, your rights and enforceability in the respective jurisdiction. How will you repatriate money, as a global investor or as a domestic investor, depending on the structure that you're investing in. There are certain valuation considerations that come into play when you're looking at investing in an Indian company versus investing in a holdco which has an Indian subsidiary. So it is important to understand, because every structure, except for when you're investing in a plain vanilla India entity, which has no other holdco or a subsidiary in or outside India, every structure will come up with its own, nuance with respect to legal and tax, for you as an investor particularly. So very important to understand that. Second is, also from a legal entity perspective, you need to understand where the IP really lies of the business, right? So let us say you're investing in a Indian subsidiary which has a holdco in the US. While you may be coming in and infusing capital in the subsidiary entity, your IP may be resting with the US entity or vice versa. In which case you need to have in place proper agreements which will show the IP flow in a manner which works in your favor as an investor, which basically ensures that value is captured at that entity in which you're investing. And which is why the most important thing for you when you're looking at an entity to invest is what is the structure that the entity has. The second is assessment of business plans vis-a-vis the charter documents. Again, a little technical to that aspect. What you need to understand is, obviously, as part of your presentations, when the founders make to you, they would have projected certain activities, or they would have business projections for the next few years. What you need to analyze is with respect to the charter documents of the company and what the company has already in place. Do all these fit in properly as per what is stated in their charter documents? Does the business activity that they are conducting as of today within the four corners of the charter documents? So that's straightforward. That's something that your lawyer will help you with. But again, you need to just keep this in mind while you're looking at evaluating an investment opportunity. The third and perhaps a little relevant, not as much across the board, is whether the startup that you're looking to evaluate for an investment opportunity has a registration under the Startup India scheme. Now, Startup India scheme obviously requires certain parameters to be fulfilled for a startup to be able to register for the eligibility of a startup. Given that your startup is registered, you will have certain tax exemptions and certain holidays that you will enjoy under the Startup India scheme. There are challenges which the entities do face while they are trying to register for the Startup India, including for example, getting the registrations in place, getting the registrations and certifications in a timely manner. So not that it applies across the board, which is what I mentioned, peculiar, but in case your startup has that registration, the startup will be eligible for certain benefits, and you will ride along with that as you invest in the company. The fourth important thing for you to consider, and which is more documentation driven than entity specific, is are there any prior investments in the company which have already been made? What are the kind of investments that the company has received? Is it foreign investment? Is it a mix of foreign and domestic? If so, what are the documentation that the company has put in place to govern the rights, the inter se rights and obligations between the shareholders of the company? I'll run through some of those points in the next slide when we deal with the more documentation specific and legal concerns around that. But you need to have a knowledge of that when you're evaluating an entity. The next one is on company policies. Again, more of a legal diligence point, but to understand what are the kind of policies that the company has in place, and given the number of incidents that we have been as an industry, as a startup industry, encountering in the recent past with respect to corporate governance, and how there have been for lack of better terms, malfunctions at internal levels, where things have blown up out of proportion, and we are reading about it all in the news. It's important to understand what are the internal policies that the company has in place, to generally manage corporate governance, and obviously the mandatory ones included, like a policy on sexual harassment. Do you have a policy around anti-bribery, etc.? A lot of investors also want the startups to align their policies in line with the investor policies at large. The investors may have a global policy on certain specific areas, certain key focus areas, and in which case you may want the startup to align with that. So, checking on the general health of the company with respect to what are the kind of policies that they have been maintaining, and what are the kind of steps that they've been taking under those policies to ensure proper governance, I think is a key again, and specifically in light of recent incidents. The next is business assets. You need to have, some kind of a sense around, or conduct a technical diligence on kind of assets that the company owns. Are they really relevant? Do you want to peg your consideration or your subscription monies to the assets that the company owns? And the last is insurance coverage. So what is it that the company has in store, not just for its assets, but very importantly for its directors and officers? Because as an investor, you may want to place, you may have the right, you may want to have the right to have a nominee director on the startup. Do you have adequate insurance coverage for that? Moving on to the people specific considerations, as we call it, we need to make sure, and I'll club this into two broad buckets. Obviously, as people specific considerations, you may want to understand, one, who are the key promoters and the key managerial people who are behind the show. You will really be betting on the jockey here, and not the horse. So to understand those people, doing a background check on them, to understand what are the kind of startups they've floated before in a time and age that we are all in. It is more likely that your your startup founder, or the founder of the company that you're looking to invest, has already floated 5 startups, failed or succeeded with either. So good to have a knowledge of that, as well as some of the key managerial guys, the CEO, the CTOs, and the CFOs, etc. So a knowledge of the promoters and a key managerial person is very important. Uh, on the agreement bit, I think, while you will conduct a legal diligence on the kind of documents that the company has, your shareholders agreement and knowledge of the founders agreement, and the rights that are encapsulated in those documents for the founders and for the other investors who might have invested prior to you, is very important. That will, one, give you a sense, in terms of how the company has played out thus far. What are the kind of rights that have been given to the prior investors, and whether you want those rights or not. Uh, the other important factor is, you may not want certain rights to be given to the other investors, which have, even if they've invested prior to you. And how would you then play it out? Will you reopen the entire shareholders agreement, renegotiate all those terms with all the shareholders sitting up front? The founders today are not very amenable to the idea of reopening the negotiations with their existing investors. There is a lot of pushback that we see now in our experience, that is coming from the founders and the existing investors on the table. So you have to really think this one through, and determine what your rights are going to be. A knowledge of these agreements prior to the term sheet stage may or may not be possible for you. And so when you agree on the broad rights under the term sheets, be mindful that some of the rights that you may have asked for at the term sheet stage or the LOI stage may not really translate into in a manner and in a format that you would have envisaged then, because a lot is dependent on the negotiation that you will have with the founder, the company, and the existing investors when you get into the documentation stage with them. So I think the most important document for them, for you as an investor to consider, is the shareholders agreement and the share subscription agreement. From a founder perspective, I would say, of having a founders agreement in place, or a co-founders agreement in place, more specifically in a situation where you have multiple founders, is very important. And that you should have, starting day one of the company, and not wait for a formal shareholders agreement where, you will get your first set of investors, and that's when you will really have that. Your co-founders agreement should basically lay down clearly your liabilities with respect to each other and towards the towards the company in a scenario where your startup fails. And we have seen co-founders agreements getting picked up and enforced in a situation where the founders could not see eye to eye. And having a robust agreement in place from day one would really help you navigate through such through those kind of difficult times when you really want to exit or give an exit or facilitate an exit to one of the founders when things don't go well with you. So from a founder's perspective, I think the founders agreement is a very important document much before this SHAs can be put in place with the investors. Uh, with respect to your, again, going back to your legal health of the company and how well are you driven, it's important that you need to have you need to show before an investor comes in that your house is ready for the investment. So compliance with labor laws could be just one critical point, but compliance in general with all the specific laws that are important and are applicable to you and for you to run the business on a day-to-day basis is very critical. We've obviously seen the risk appetite of the investors increasing over time. They have been able to swallow risks associated with minor non-compliances here and there under the Companies Act, under secretarial standards, etc. But yet, I think when an investor does a diligence, there is a fair amount of emphasis placed on how compliances have been run, and a lot of purchase price or subscription amount considerations are driven by the fact that they see a lot of non-compliances, how those non-compliances are proposed to be rectified, whether the entire decision of the investor putting a director on the board from the closing date or thereafter is also dependent on how the legal health of the company is as of the closing date. So while I understand and appreciate, and I keep hearing from a lot of founders as we interact with them, that we're too busy with business and there is less time to focus on compliances in general, and it's something that we keep aside for the time. I think it's very important to have in place the right set of people who will manage these compliances for you. Because ultimately it's the founder who will be put on the spot for ensuring that these are done in your share subscription or your shareholders agreement. So it's important that you keep a sight of this right from day one. Sorry. Moving to the last slide on business specific considerations, I think the first two are straightforward. You need to have and you will have a knowledge of what is the product or the service offering that the company is offering, what is the kind of product or the service that the company has promised will float in the next few years, and basis that you will make a commercial call whether to invest or not. I think the only two important things on this slide from a legal perspective really that you need to focus on is the kind of contractual arrangements that the company has with its clients, with its vendors, with its service providers. Has the company taken over any onerous obligations like indemnification without an upper limit, or any kind of payment obligation that the company assumes which look out of the ordinary to you? So you need to look at those contractual arrangements and see if that is something which ties in in terms of ties in with your perspective in terms of doing business in the kind of product or service offering that the company is in. And the second one I would emphasize is the licenses. And I think we'll run through some of the specific laws that apply to you when you are in a medtech industry, post this slide. But ties up to the same point around compliance or the legal health of the company. The company needs to have the bare minimum licenses and registrations which are mandatorily required by the company to have under law. Now, whether a lot of times what we hear from clients is that it is something which is not as important, so we've not procured it so far. It is something that we will do it in the course of time. That does not help and does not pass the muster of of the investors more often than not. We do see red flags coming out of such situations where the license and registrations are amiss, or if they've expired and they've not been renewed. So an adequate amount of attention is required to be paid both by the founders and the investors while they conduct a diligence on what is required to be had by these companies and whether they have it or not.
So when a startup comes up with an idea, the idea itself can often be very revolutionary, and on paper it can sound great, but unfortunately the healthcare space as a whole, and when I say healthcare, I include pharmaceutical medical devices, healthcare services, all of these. They're heavily regulated. So as you can see on the screen right now, there are several laws that apply to just the pharmaceutical industry. And mind you, this is not an exhaustive list. These are just the primary ones that apply. Essentially, every element within the healthcare industry is regulated. So when you are evaluating a product or a service offering, it's very important that you are aware of the legal framework that regulates it, because it heavily influences how viable the business may be. So we can go to the next slide. So this is the legal framework for medical devices. I'm not going to go into much detail right now, but again, as you can see, there are a myriad of laws and regulations that apply. So everything from the manufacture, the sale, the distribution, the labeling, the claims, the price, everything is covered under the law. So there are certain restrictions that come into play as a result. Similarly, the healthcare industry, by which I mean healthcare service delivery, is also very heavily regulated. So right from your healthcare professionals to specific healthcare services like mental health care or fertility, like reproductive reproductive services, women's health, all of them are very heavily regulated. Then clinical establishments, which is like the likes of clinics and hospitals, are also regulated under the laws. There are restrictions that come into play there as well. Telemedicine is also regulated. You've got the Consumer Protection Act, under which action may be taken against a healthcare professional or a clinical establishment if the standard of care that they provide is not up to the mark. So that's that can actually be quite an onerous it's quite an onerous compliance. Even if you're offering it digitally, if you're offering like teleconsultations, the concept will still stand. So with that framework, there are certain considerations that you must take into keep in mind when you're examining a startup and whether the concept is viable or whether it's a viable investment. So the first thing that it's important to look at is the intended use. And essentially what that means is what the product or service intends to do. So if the intent is to diagnose or cure or mitigate a disease or disorder, chances are it will be classified as a drug or a medical device. And that will it'll invoke the laws that I mentioned above, the ones that apply to drugs or medical devices. And that is accompanied by very stringent licensing requirements. Like I said, every aspect of it calls for a license or an approval in some form, and there are compliances that accompany each of these licenses. So overall, it can be quite an onerous and expensive undertaking. As you may have noticed, a lot of these laws are not new. A lot of them are digitization as we know it today. So unlike with a lot of other industries where you can follow the move fast and break things motto, that would not necessarily, that would likely not be possible with healthcare, because at the end of the day, the customers are patients and human lives are at stake with each of these things. You also face more resistance from consumers than you may with certain other kinds of businesses. For instance, when it's grocery delivery or ride sharing or something like that, once you have consumers hooked, it's fairly, it's chances are they're not going to revert to their older ways. But with healthcare, it may not be the same because ultimately nothing can replace the doctor-patient relationship and the advantages of a physical consultation or a trained professional monitoring your progress or whatever the in-person equivalent may be. Product liability is another huge monster that comes into play here. Essentially, a manufacturer or a service provider are liable under law for any defect or deficiency in a product. And like, for instance, if a medical device is to malfunction as a result of some sort of manufacturing defect, the financial and reputational damage to the company can be massive. It can quite literally bankrupt a company. Then, as a result of how regulated the healthcare space is and all the licenses that come into play, there are also certain restrictions that may come into play when it comes to expansion, because a lot of these licenses are specific to a territory. The laws tend to vary from, at the very least, from country to country. So it's not very easy for a startup that's, that deals in a drug or a medical device or a healthcare service to expand overseas. They would sort of have to reevaluate their entire model against the legal framework of the country that they're looking to expand into and see if it works there. And there could be significant costs associated with being able to expand. Even within the country, there could be certain restrictions because certain licenses may be state specific. So that could also pose challenges. With drugs and medical devices specifically, they can only be sold with certain exceptions. For the most part, they can only be sold under a license by a licensed individual. As a result of which, you have fewer sales avenues that are available to you. It may not always be possible to list your product on, an Amazon or something. So that also is something that ought to be considered because, there are fewer ways of reaching your customer. There are also significant restrictions on promoting products that are deemed drugs and medical devices. While we now commonly see a lot of products being promoted on social media through influencers, it's not always possible for a medical professional to be involved. I mean, a medical professional cannot be involved in such promotions. It would be unethical. So there are severe restrictions on how a product can be put out there. And while you may want to make these very catchy claims about your product, it may not always be possible because claims are also heavily regulated. And tying back to the first point, intended use, a claim alone can make the difference between a product being a wellness product versus a drug or a medical device, and the regulatory framework that would be applicable to the two would be completely different. So that's something that has to be very closely examined.
Thank you, Rishika. I'm sure the past couple of slides might have given you a heavy download of how regulated the industry is, or the kind of compliances that every startup to actually be viable, or for the investors to actually feel the startup to be viable, need to look at. But it's something that every startup or every investor should use as a guide, which is the entire purpose of this presentation, and not run away from, I mean, we're not here to discourage you from investing, but we're here to tell you that there is certain guidance here or available with rather any lawyer or any informed decision maker who can guide you on what to look at in terms of compliances or the future potential compliances that any startup which wishes to, enter the health or healthcare arena might or should be in compliance with, so that you know that your investments are going in the right direction. So two things that I will be discussing are intellectual property considerations and data privacy considerations. We hear these words everywhere. Data privacy, in fact, has become the buzzword in the recent couple of months, given the new law. But intellectual property first, when I deal with intellectual property, this is one of the most important asset that any startup could have uh, in terms of tangible assets, right from the name of the startup, which is very essential when you look at incorporation itself, to branding. Intellectual property plays a major role. When you have your products, you have ideas and you have concepts that go into the making of your products or services. They are all intellectual property. And today, or as a matter of time, these intellectual properties will mainly be the assets for the startup. It's very important for the startups to plan their intellectual property management in terms of the kind of registrations they might need for the trademarks, or the way they can protect these trade secrets through non-disclosure agreements between people who do get access to these confidential informations of the startup, because that exactly makes the startup unique. That if you do not have the rights to your brand name, you can't use those brand names for advertisement. What if some other startup might pick it up? But when you don't have the rights, you can't really claim any protection on those grounds. So even if they do not have the rights, when you are looking at investing, it's very important for the investor to look at what their intellectual property management plan is for any potential assets that the startup might generate. And they can safeguard this by entering into agreements with the relevant stakeholders, getting assignments from another party that might own an IP that the startup might be interested in, or might use that IP for any of its brand promotions, offering of services, or product marketing, or manufacturing and labeling. So in these instances, IP considerations become very important for any startup. Second, when I do talk about data privacy, the entire purpose of running an application or running a startup that deals with any data of an individual, say personal data, which might have their contact details, their addresses, or any data that might actually identify that individual. So this would be a little specific to the nature of the startup. If they do have a consumer facing startup which does take up data from personal data from individuals, you will have to look at what their privacy requirements are. Are they planning on having policies in place or taking consent from individuals? Because the data privacy framework as of now, when we talk about personal data of individuals, is in transition to a new law, although there are certain provisions which require compliance throughout. When you do plan on taking up information from individuals or offering services to individuals through online mediums as well, you do need to have a privacy policy in place. Now, these privacy policies do have separate requirements in terms of how the consent can be taken, or offering these privacy policy notices to individuals when you are collecting their data, or security measures. In fact, when you are collecting data, you need to ensure that a certain basic security, cybersecurity measures are in place. Now, these are preparations that the startups might pick up eventually, even if not in the early stages, but a planning or awareness regarding the kind of compliances that they will have to undertake in terms of personal data handling would be very important, because any breach or any impact on the data of an individual can impact their liability potential under the existing as well as the law that is being implemented in eventually. So I think with this we end our presentation, and we would be taking up questions from your end, if any.
I will take up one of the questions we have in the Q&A chat box. The question is, can you comment on enforceability of founder agreements founders agreements, how quickly can injunctions or other actions be achieved to actually be effective in enforcing these agreements in court or other means? So enforceability of a contract, so long as your contract is properly worded and has has the adequate clauses around dispute resolution, etc., is not a challenge. We've been able to move injunctions and get them for in one of the recent cases that I was mentioning fairly quickly, depending on how grave the situation is, what is the kind of dispute you're alleging, etc. So it is, again, it all depends on how your contract is worded and whether it gives you the flexibility as a challenging party to move the court for enforcing it in your favor. Ishika and Tanya, you may want to take the licensing regulations question.
Yes. So to answer your question, yes, the licensing regulations may differ from state to state. The regulation itself in India is typically at a central level, but the license may be given either at a central level or at the state level. It would depend on the license. For example, a manufacturing license for a drug or a medical device would be granted by the state licensing authority, and that would in fact be premise specific. So even if you've got two premises within the same city, you would need separate licenses for them. But some, there may be certain licenses such as, like a healthcare practitioner's license to practice. That, while again state specific, while granted by a state licensing authority, sort of gives them the right to practice across the country if they're consulting through telemedicine. There are restrictions if they're consulting physically. So it would largely depend on what the license is for and what the situation is.
Hi, Tanya. So sorry, there was some issue with my system. I guess there were two questions in the Q&A, and of which I guess both of them have been answered. Great. In case anyone would like to have any quick question or concern. Okay, I see Mr. Lakshman has raised his hand. Give me a second. I would quickly unmute you so that you can ask your question directly. Lakshman, meanwhile, can you type your question in the Q&A? I've given you the permission to unmute yourself.
Yeah, can you hear me now?
Yeah.
Okay, thank you. So my question is, these days software are also treated as a device. So software as a device needs to be registered and approved by the ministry. And the software can be used on any physical device. It can be used on a smartwatch. It can be used on the chest strap. It can be used on the bracelets. It can be used on the armbands, etc. In such cases, how do you ensure the privacy of data, and particularly the storage of data pertaining to the Indian patients on the Indian servers?
Thank you for the question, Mr. Lakshman. So, as rightly questioned by you technically, there is a lot of digitization, and we understand that there are a lot of variables that come into play, and the software is being made applicable to the hardware device. That's the variable. Here, the software, yes, as an independent, they will be regulated as an independent device, and when I'm talking about the data privacy aspect specifically, which your question really was, the requirements under the data law specifically regulate where the data flows, or how the data can be protected, where the data can be localized. And in terms of collection of data from these variables at the central network is that will have to, ensure the data retention or compliances with the Data Act. The Data Act clearly provides when the data can be transferred, when the consent is required for transfer, and how your data must be protected at the site of, collection and processing of these data. So when a company is putting up a software in a wearable device and therefore collecting data from that wearable device, for now, let's keep it as Indian consumers. The company who is collecting such data, processing such data through the wearable device will have to ensure compliances, and those security compliances for the personal data are a requirement under the law itself.
Okay. Thank you. Thank you.
I hope that answers your question, Lakshman.
Yes, yes.
Great.
Thank you.
In the interest of time, we might not be able to take any further question. So anyone, any of the participants, if you have any follow-up query, feel free to write to me. My email ID is aditi@bioangels.vc. We would, be happy to connect you with either of Harshita, Ishika, or Tanya to get your queries resolved. With this, we come to the end of the discussion. I would like to thank all the speakers, Harshita, Ishika, and Tanya, for giving us, great insights, not just into the legal part of it, but also briefly touching on the regulatory aspect, especially, how you subcategorize the healthcare domain per se into, services, devices, innovations, etc. So it was quite insightful. Thank you, everyone, and for everyone present in the audience. This is a 3-session series that we are running with Nishit Desai. So stay tuned for the next session. It would happen very shortly in the early first week of December. So of course, we'd send you the follow-up session. Great. Thank you, everyone.
Thank you.
Bye-bye.